Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular video, we're talking about VAWA, or Battered Spouse Petitions. Now, VAWA stands for Violence Against Women Act, and a lot of times, as I've seen through the years, what happens is people will immigrate to the U.S. and the spouse will all of a sudden turn evil and mean and basically not do anything in regards to petitioning the spouse, will abuse them physically and or mentally, will basically have them, most of the time the wife, living in hell, afraid that if they say anything, do anything, that they will be deported, because that's what the husband is claiming will happen, and that what the husband will do. They make no police reports many times, yet they have bruises, they have been hit, they go through psychological torture basically, and they're at the end of their ropes, and they're basically living in a place where rather than go back to their home country, which is even worse, they just live day after day, month after month, and sometimes years under the oppression of what their husbands are doing to them. So the question is, what can they do under immigration law that allows them to get out of this oppression, to not have to live with the psychological hardships that are occurring, without having to be beaten or suffering physical abuse? What can they do? Well, under VAWA, the Battered Spouse Petition, they are permitted to file what's called it's under the I-360 form, but they are permitted to file a petition without the knowledge of their husband, without the help of their husband, and without him ever knowing that she is doing this. She does not have to stay in the same house with him. She doesn't have to stay married to him. She can get out and she can apply for the VAWA essentially right away, without any fear of reprisal, of deportation from her husband calling and so forth. One of the reasons they came out with the VAWA is so that basically women wouldn't have to live under these conditions and continually be either beaten or tortured or whatever it is that's happening, and they wouldn't have to suffer the abuse. There used to be laws saying that you had to file within 2 years of the divorce and so forth. Unlike other areas of immigration law, this particular area has actually gotten more lenient, and it's gotten easier, if it's done right, to get approved. So if you're one of these people that are being abused, there's no need for it anymore. You don't need to live like that. Get out, go to a shelter, go to a family, go to a friend, do whatever you need to do, and then, of course, without telling your husband, you need to get it prepared. So when the procedure is that the VAWA petition gets filed at the Vermont Service Center, and if it's approved, then you can apply for adjustment of status for lawful permanent residency. Now, there's also the path of doing the VAWA basically in immigration court. So let's say you do get put into deportation proceedings or removal proceedings. If you can show that you have 3 years of residency, and then you show all the elements for abuse, then you can qualify for special rule cancellation of removal for battered spouses. So either way, whether you're in deportation or not in deportation, you'd be able to apply for the VAWA. And then let's say it's the one that goes to Vermont. What happens is, after they approve, you will be able to get a work permit during the pendency of the adjustment, and then you apply for the adjustment to get your green card. You can then should you need to, or even before actually, get out of the situation of your home, make the police reports, get the district attorney to charge your husband for domestic violence. Don't live under the fear of oppression, and you can go forward and get everything you need with the VAWA. Now, what does the application, the typical application, include? Well, for my part, when I prepare these, the most important part is the declaration from the person who's being abused. Now, normally what I do is I first ask her, I say, just, write me as detailed of a statement as you can as to what happened, when it happened, why it happened, how it happened, just be as detailed and what was said. There's usually very crass things that are said by the husband to the wife, sometimes shocking things that are said. But then what I do is I look at everything that was written as far as what she wrote, and of course I make the declaration pretty and with all the necessary items per the facts of the particular case. It's reviewed by her and then ultimately signed. Do the attorney cover letter. Then I ask her to provide, if there is any photographs, for example, if there were bruises, any police reports, any temporary restraining orders, domestic violence charges, any of that, if it exists. But keep in mind that even if it doesn't exist, it's not a bar to getting a VAWA application, a battered spouse, a self-petition approved, because immigration knows that a lot of women will not follow up with the police or make reports out of pure fear and because of abuse. And if even if there was a crime committed, if you can show that the reason that it was committed was linked to the abuse somehow, then there are waivers available for all the crimes. So there's easier waivers, and the burden of proof is less than in many other petitions. So there's an encouragement by U.S. law to get out of the abusive relationship and to file a VAWA. So then after I put together the attorney cover letter, the declaration, the temporary restraining orders, any police reports, and all the necessary exhibits, and also possible supporting declarations from people who have seen the abuse, the apartment manager, for example, family members, so forth. I also recommend a psychologist or psychiatrist that will give an evaluation of the abuse, what has occurred, and what his or her professional opinion is of how the person, the wife, has suffered emotionally and or physically. And I attach that as an exhibit as well. And then once that's done, it then gets filed and goes into the system. And just so you know, let's say the husband does find out that you are filing the battered spouse petition, and he writes this 20-page document of how terrible you are and how you lied and how you only married to get the green card and all this other stuff. The law says that the person adjudicating the VAWA petition cannot use or consider anything that the husband might send. And if the adjudicating officer does rely on it, does use it, then basically it's a violation of the law and you can have your case reopened and reconsidered. So don't even worry about what your husband might send or write to immigration. So given that this is just a very brief overview of the VAWA process, the main purpose, which I've sort of integrated through this video, is you don't have to stay in your terrible situation. There's relief, there's ways of getting out, and there's ways of doing it properly. So if you'd like to have a consultation on it, give me a call. Go online, set up a time, and I'll be happy to help you out and let you know what it would take to get a good battered spouse petition and VAWA out the door to the Immigration Center. Okay, more on the coming videos.